Hi, this is Julie Davis, and I'm here with RiskCommunities. I'm here for another film segment on various different business insurance and risk management matters for technology firms with some of our experts. And I'm here again with Scott Goddess. Scott, how are you?
Great, thanks. Good to be back.
Great. Scott, the technology sector is certainly doing much better, actually good in the marketplace, and we're all pleased about that. And many of the IPOs have increased, which is great. And so you get a lot of emerging technology companies that are traveling that path from organizational startup to maturity, which is really great news for our economy. And we get a lot of questions about risk disclosures in general. And the questions that we get really result from risk management being a lot more visible than it was in the marketplace as compared to 5 or 6 years ago. And we get a lot of the corporate boards asking, have they identified all the proper risk in the organization? And are those risks any greater than they were 12 or 24 months ago? So specific to risk disclosures, I want to just narrow it down and ask about how that trickles down to your insurance policy renewal, and what should people be thinking about as they renew their insurance programs?
You absolutely should think about that and multiply the risk of being asked about your disclosures and whether they were sufficient with the new laws that have been passed in terms of disclosures for public companies. It has a great impact on insurance. And from both what I would call a macro level and a micro level. The macro level means if your company is going to be facing additional risks because of additional required disclosures and new state and federal laws that affect public companies, of course it will affect your insurance program, and you should consider what limits you should have, what types of policies you should have, and again from a macro level, should you have specific programs for your directors and officers. So for example, you might buy independent director liability coverage, or you might buy additional what's known as Side A coverage for your directors and officers, which says that if your director and officer is sued, has a claim against him or her, or something else that triggers the policy and is not reimbursed by the company for those costs, Side A coverage should apply. And so with an outside director or officer having his or her personal assets potentially on the line for inquiries like that and situations like that, the interest in having higher limits for Side A coverage or independent director liability coverage, of course, has really taken the front seat, and really people have started asking quite a bit about that. And I've gotten a lot of inquiries about an article that I wrote about independent director liability coverage. Now, beyond the macro level, we should keep in mind the micro level issues. What I mean by that is sitting down and talking with somebody who really understands how the policy language has been interpreted in a way by courts that could affect the company. So for example, if you have a directors and officers insurance policy, does it have what's known as a priority of payments clause, which says that the insurance policy will apply in a certain way such that it may apply first to directors and officers before it applies to the company if the company bought Side C or entity coverage. And other things to keep in mind. For example, made a big splash in the news for the Allen Stanford insurance policy, where there was a clause from one of the exclusions that said that the coverage would apply unless there was a finding of facts that met the money laundering exclusion. Now that was different language from language known as the quote-unquote final adjudication language. Now, why that's important, even if it seems like a pretty geeky insurance point, is that if the final adjudication language applies, it means the insurance continues to pay your defense costs, which a lot of times can be the tail wagging the dog, until there's been a final adjudication, a final ruling that there are facts determined that would make the exclusion apply. The other situation was something that could be done in the insurance coverage lawsuit, and the insurance company said it itself could apply the exclusion. Perhaps no surprise that the insurance company wanted to apply the exclusion very quickly. So Stanford found himself without a defense being provided, without insurance potentially being available earlier than he otherwise would have had that clause had the more favorable language for insureds and for policyholders. And so, again, both on the macro level, how much is being bought, what type is being bought, and on the micro level, It's the coverage that you're actually buying. How will that apply in a worst case scenario is a key to understand in this new environment.
And there's also one additional thing. It doesn't just apply to the directors and officers liability, but also a lot of the new areas such as cyber liability. I know there's been some legislative movement to make sure that some of those disclosures about data breaches and privacy issues be included in the risk disclosures. So I guess making sure that the cyber liability policy is designed to cover the things that are important.
Absolutely. You want to make sure that you're going to be getting coverage for a cyber attack, a denial of service attack, a data breach, or other type of event of that nature. You want to make sure that you'll be getting the coverage that you'll need if you're in a situation where you have to make a disclosure and there has to be an inquiry, and the costs that are related to remediating and taking care of the event and basically cleaning up from an event like that. And so you have to understand that if you look at your directors and officers policy and there is an exclusion that relates to events of that nature, that you want to make sure that you have another policy that provides the coverage that will fill in where it's been otherwise excluded. Because the costs related to this, even if it turns out your company did nothing wrong, to just defend it alone can be astronomical. And that's what you want to have insurance for, is to transfer that risk to the party that can pay for it and that can provide the claims handling, can provide you with the services that you need and the payments for it.
Thank you, Scott, so much. It's really important whenever you look and review again constantly the risk disclosure issues. Really appreciate it.
Thanks, Julie.